seated. Does any member wish to give a notice of a motion? Notice of a motion. Honorable Hatting.
Thank you, Honorable Chair. On behalf of the Democratic Alliance, I hereby wish to move with notice that, in view of the latest international incident caused by the Blue Light Brigade of the Northwest Premier Supramau Mapelu, forcing Botswana President Ian Khama off the road in Botswana, and that Northwest members of this House, you included, were recently reported not only at speeds exceeding 120 kilometers an hour in the 60-kilometer zone, also involving solid line overtaking and not stopping at stop streets and red traffic lights, that this House debates the legality and the risk involved not only for members but also for the public in the travel of elected public representatives in blue light brigades. I so move.
Thank you. Honorable Blanche.
Thank you, Honorable Chairperson. On behalf of the Democratic Alliance, I hereby move a notice of motion that at its next sitting, this House debate the spillage of untreated sewage in the Vaal River system and the detrimental impact that it has on both humans and animals dependent on this water resource. I so move.
Thank you. Those with the two hands have noted, honorable members. Honorable members, does any member wish to move a motion without notice? Honorable Chief Whip.
Thank you very much, Honorable House Chair. I hereby move without notice that the Council notes that yesterday, the 6th of November, marked the 53rd commemoration of the death of a gallant fighter of the National Democratic Revolution, an incisive trade unionist, V.C. Lemini, who was one of the first ANC members to be executed by apartheid state when he was executive on the 6th November 1964. Further notes that V.C. Lemini, who was also a prolific organizer and a secretary of the South African Congress of Trade Unions, SACTU, and the secretary of the ANC Cape region, was hanged together with Wilson Kainga and Sinakile Mkhaba. In 1952, he was jailed with Governor Mbeki and Raymond Mhlaba for 3 months in Royal or North End Prison, Port Elizabeth, for participation in the campaign of defiance against unjust laws in what was famously known as the Defiance Campaign. He was also one of the 156 defendants in the famous Treason Trial of 1956, and takes this opportunity to pay homage to this gallant fighter of our movement for his selfless service to our nation. Thank you, Chair.
Thank you. Is there any objection to the motion? The motion is agreed to in terms of Section 65 of the Constitution. Honorable Ncita.
Thank you, Chairperson. I hereby move without notice on behalf of the African National Congress that the Council notes that the remains of the 12 United Democratic Front martyrs were returned to their families during the ceremony in Port Elizabeth yesterday. Further notes that all were buried in pauper graves in Pretoria and exhumed without the proper burial without consultation of their families. They were exhumed of their remains as a result of the painstaking work of the National Prosecuting Authority, Missing Person Task Team. Also notes that the gallant fighters were executed in Pretoria in last days of the apartheid system, which those comrades dedicated their lives to the liberation of the oppressed masses of South Africa. Therefore, sends our heartfelt condolences to their families, friends, and comrades of the martyrs, and wish them a strength during the burial period, which take place Saturday, the 11th of November. I so moved.
Thank you. Is there any objection to the motion? The motion is agreed to in terms of Section 65 of the Constitution. Honorable Mikalakis.
Thank you, House Chairperson. On behalf of the Democratic Alliance, I hereby wish to move that Council notes that today would have been the 100th birthday of anti-apartheid icon Helen Suzman. Ms. Suzman was the Member of Parliament for Houghton from 1953 to 1989, 13 of those years being the lone voice against apartheid in Parliament itself. Ms. Suzman is often criticized by those who wish to deny her legacy that she gave legitimacy to the system by sitting in the old Parliament. But in her own words, those critics were all too willing to make use of her work in order to fight the Nats. Her contribution to bringing about the end of apartheid is undeniable. President Mandela himself had this to say about Ms. Suzman. Her courage, integrity, and principled commitment to justice have marked her as one of the outstanding figures in the history of public life in South Africa. In the spirit of unity, in which icons such as Ms. Suzman, alongside people like President Mandela, set out to build a democratic South Africa, I am sure the whole House will join me in paying our respects to this remarkable South African. I so move.
Thank you. Is there any objection to the motion? The motion is agreed to in terms of Section 65 of the Constitution. Honorable Motara.
Thank you, House Chair. On behalf of the ANC, I hereby move without notice that Council notes and welcomes the pronouncement by the Nelson Mandela Foundation, together with other relevant stakeholders, that the late Nelson Mandela's primary residence in Houghton, Johannesburg, is set to be transformed into a presidential 5-star tourism product. Also notes that the centre is set to consist of 9 bedrooms and will be a boutique hotel that will attract a primary market of high-end business travellers, the diplomatic corps, and scholars from around the world, as well as a secondary group of leisure travellers. Further notes that Nelson Mandela was a walker and traveller who made a difference in the lives of those he met and those he travelled with, and that this unique project with iconic status will offer an experience inspired by Madiba's life while he resided and worked at the property, and will attract more people to explore tourism offerings in South Africa. Therefore, applauds the Foundation and the stakeholders on the initiative that also contributes to the preservation of Mandela's legacy. I so move.
Thank you. Is there any objection to the motion? No objection. The motion is agreed to in terms of Section 65 of the Constitution. Honorable Mtetwa.
On behalf of the African National Congress, I hereby move motion without notice that the Council notes with utmost concern the brutal killing of the chairperson of the Sizwe Tax Association, Mr. Sizwe Obed Nkomande, which is embroiled in an ongoing conflict with the Cleaver Tax Association of the lucrative Ladysmith Johannesburg route. Further note that the killing of Mr. Nkomande follows a shootout in Ladysmith last Tuesday, which left 10 people dead, including Cliff River Tax Association Deputy Chairperson Mr. Ifan Ngobese, his daughter Nozipo, 2 bodyguards, and his driver. Take this opportunity to convey its heartfelt condolences to the Nkomande family and condemns in the harshest possible terms the violence and senseless killings between members of the Sizwe Tax Association and Cliff River Tax Association, and call on the Minister of Police and Minister of Transport to intervene and bring to to an end the senseless killings that continue to rob families of their loved ones and breadwinners. I so moved.
Thank you. Is there any objection to the motion? The motion is agreed to in terms of section 65 of the Constitution. Honorable Matebula.
Thank you, Chairperson. I rise on behalf of the EFF for the Council to note that Oscarine Masuluke from Momankena village in Guyana, Limpopo province was nominated for the FIFA Push Call Goal of the Year. Note that Masuluke represented South Africa and African football at the global stage, one of the only 3 South African players to ever be nominated for the award. Recognize his talent and determination to sports, in particular soccer. Even though the award have passed and Masuluke was not successful, his nomination on its own was an achievement and he must be congratulated. Call on the Council to send a congratulation note to Masuluke for his achievement and the world recognition. Thank you.
Thank you. Is there any objection to the motion? The motion is agreed to in terms of section 65 of the Constitution. Honorable Mhlanga.
Thank you, Chair. On behalf of the ANC, I hereby move without notice that the Council note profoundly concerned by the national taxi strike that is aimed for Wednesday. Also note that this activity happens during our critical examination period that could affect the learners who are sitting for their exam, more especially the grade 12. Therefore, appeal to the parents to take precautions and prioritize safety during the national taxi strike on Wednesday, and urge all the necessary stakeholders to resolve the dispute without inconveniencing the people. I so move. Thank you.
Thank you. Is there any objection to the motion? The motion is agreed to in terms of section 65 of the Constitution. Honorable Kimbi.
Thank you, Chairperson. On behalf of the ANC, I hereby move without notice that the Council notes with great shock by the cold-blooded murder of Comrade Siabulela Twalani outside a friend's home in Khayelitsha last Saturday. Also knows that the 41-year-old, the head of Cape Peninsula University of the Technology's residence on its Cape Town campus, sustained gunshot wounds to his head and face, and nothing was stolen from him. Further notes that he was an activist that prominently involved himself in NEHAW, ANC, and the Alliance at large in the Western Cape, and that his memorial service will be held at CPUT, Mowbray campus, and further at Tusong Center in Khayelitsha on the 9th of November 2017, starting at 12 p.m. and 17 p.m. respectively. His ultimately departure is not only a loss to his family and our glorious movement, but to the entire nation. Therefore, our prayers are with his family and friends. And this trying time, may his soul rest in eternal peace. uThixo ambusise. I so moved.
Is there any objection to the motion? The motion is agreed to in terms of section 65 of the Constitution. Honorable Prince.
Thank you, Chairperson. I hereby move without notice on behalf of the African National Congress that the Council notes that the remains of Michael Lucas, a young man from Oudtshoorn, were reburied on Saturday, the 4th November, after being executed in March 1988. Further notes that Michael Lucas was executed as a young principal and religious Christian who refused to give information despite the threats and death sentences. Also notes that the trial in the Western Cape Supreme Court was presided over by Justice Dennis Williamson, who was then known as the hanging judge. Therefore, call on the state and public in general to view the story of Michael Lucas in all its nuances in order to ensure that we never return to a death penalty in future. I so move. Thank you, Chair.
Is there any objection to the motion? The motion is agreed to in terms of Section 65 of the Constitution. Honorable Sifako.
Thank you, Honorable Chair. On behalf of the African National Congress, I hereby move without notice that the Council note with great sadness the passing of Mr. Caesar Vilakazi, the SABC's head of legal services, last Saturday night. Also notes that Mr. Vilakazi was shot dead in Tsakani on the East Rand after 3 armed men entered his store before fleeing without taking anything from the store. Police say 3 armed men entered his store and shot him before fleeing. Further knows that he was hired as a senior legal advisor on the 1st of December 2008, and on the 1st of September 2016 was appointed head of legal services. His meaningful contribution to the SABC will remain and continue to inspire all who knew him in his personal and professional space. He will be deeply missed. We believe that the law enforcement agencies will work tirelessly to bring the murder to book. Our heartfelt condolences to his family and friends. May his soul rest in peace. I so move.
Is there any objection to the motion? The motion is agreed to in terms of Section 65 of the Constitution. Honorable Teplanch.
Thank you, Chairperson. On behalf of the Democratic Alliance, I hereby move a motion without notice that this House notes the allegations made against the President Jacob Zuma by Mr. Jacques Pauw in his book, The President Keepers, that this House make it very clear that any allegations of corruption is very concerning, and calls upon this House to resolve to call upon the Minister of Police and National Prosecuting Authority to investigate the respective allegations and consider them for further action in accordance with the prescripts of the law. I so move.
Is there any objection to the motion? In light of the objection, the motion may not be proceeded with. The motion without notice will now become notice of a motion. Honorable Hatting? Honorable Hatting? I thought, okay, no, it's fine.
No,
Thank you. Thank you. I thought...
I just said the keepers objected.
Thank you. Honorable members, the Secretary will read the first, second, and third orders of the day.
Consideration of report of Joint Committee on Ethics and Members' Interests, alleged maladministration. Consideration of report of Joint Committee on Ethics and Members' Interests, alleged breach of the Constitution. Consideration of report of Joint Committee on Ethics and Members' Interests, late disclosures for 2016.
Honorable Singh, Chairperson on Joint Committee on Ethics and Members' Interests.
Thank you, Chair. As the co-chair of the Ethics Committee, I report on behalf of the Joint Committee of Ethics and Members' Interests on the alleged maladministrations dated 14 June.
Honorable Singh, sorry, let me deal with a point of order. Honorable Kone.
Am I protected, Chair?
Yes, you are protected.
There's a threat coming from my right here.
No. We are protected.
Thank you. No, Chair, I just wanted to welcome the Honorable Singh back. Thank you.
That is not a point of order. Honorable Singh, you are protected.
The Joint Committee of Ethics and Members' Interest, at its meeting on the 16th of March 2016, made the following recommendations on the complaints against the following member. Honorable Mabe, background. On the 13th of October 2015, the Office of the Registrar received a complaint against Honorable Mabe emanating from the Public Protector's Report in allegations of maladministration against the Passenger Rail Agency of South Africa, PRASA. The report is published as report on the 3rd of Report 3 of 2015-2016 and is available for viewing at the following website: http://www.publicprotector.org Library Investigation Report. In terms of the complaint, it is alleged that the company in which Honorable Mabe served as the director, KG Media, was improperly awarded a tender by PRASA to produce the Hamanati magazine, and this contract was unlawfully extended. The PRASA report at page 28, paragraph D, further referred to Honorable Mabe as the owner of Kuala Express newspaper. It was further alleged that Honorable Mabe, who was the former executive corporate affairs manager at PRASA, was improperly paid a salary after his resignation from PRASA in 2008-2009. Consideration of the code in respect of the allegation, section 4.1.1.4.4 and read with 4.1.5, the Code of Conduct requires members to, inter alia, uphold the law and discharge their obligations in terms of the Constitution to the public, to the Parliament and the public at large, by placing the public interest above their own interest. Section 1 of the Code prohibits members from receiving any benefits, including but not limited to a tender or contract with an organ of state. Members are also required to declare the directorship in terms of section 9.3.3 of the Code. Investigation procedure in terms of the section 10.2.2.4 of the Code. Correspondence was sent to Honorable Mabe on the 13th of October 2015, informing him of the complaint and requesting that he responds to the following questions. Question 1 was, does your resignation as the director of KG Media still stand? Do you have any financial interest in any form in KGB Media? And if so, what are the particulars of such interest? Question 3 is, are you or any company that you are associated with own the copyright of Hamanati and Kuala Express? And if you have disposed of the interest in KGB Media or Hamanati or Kuala Express, can you please indicate when the interest was disposed of and to whom? On the 20th of October 2015, Honorable Mabe requested additional time to respond to the allegations against him. This was agreed to. In his response, Honorable Mabe confirmed his resignation as the director of KGB Media on the 11th of May 2015. His 2014 disclosure reflects his interest in KGB Media. Honorable Mabe indicated that the shares to KGB Media was initially owned by KGB Media Projects Management and are currently held by Kellyborn Mabe Trust, of which he established that Honorable Mabe is a trustee and his minor children are the beneficiaries. In his correspondence, Honorable Mabe explained that Hamanati and Koala Express are newspapers for which he owns the trademark. He has submitted documents confirming this. The registrar further requests clarity on whether the extension of the contract constituted business with the state. Honorable Mabe, in his response, explained that KGB Media does not produce a newspaper for PRASA, but produces a newspaper in which PRASA buys advertising space. He included in his response a copy of the Audit Bureau of Circulation document of Koala Express and copies of the newspaper which reflects other advertisers. He alleged that the agreement with PRASA is not a tender but a contract, as it is merely for advertising space. Consideration of the report, the alleged additional salary payment took place in 2008 and 2009, which was prior to Honorable Mabe's appointment into Parliament, and thus falls outside the scope of the committee. On the allegation of the appointment of KGB Media to produce the Hamanati magazine in 2012, this matter is also outside the scope of the committee, as the contract was entered into prior to Honorable Mabe's appointment as a Member of Parliament. On the extension of the contract in March 2015, the Public Protector found that PRASA, SCM policy and Treasury regulations were contravened. She also found that there was a maladministration and contravention of Section 217 of the Constitution, which requires that the state institution creates transparent, fair, competitive, and equal system of procedures, regardless of the fact that the fair tender process was followed by PRASA. It still remains that Honorable Mabe benefited from the contract between PRASA and KGB Media. Honorable Mabe contention that the purchase of the advertising space does not constitute a tender. It refuted as Section 6.1 of the Code, in which any event applies to all, to tender, but to any contract with an organ of the state. Honorable Mabe disclosed his interest as required in terms of Section 9.3 of the Code of Ethical Conduct in relation to the disclosure of the interest. Honorable Mabe had in 2014 Registrar of the Financial Interest disclosed his directorship in KGB Media. In 2015 he had resigned, and his disclosure disclosed the interest as he was no longer a director. He had disclosed details of Kellybone Mabe Trust. Findings: the allegations of the improper payment to Honorable Mabe refers to the event of purposely incurring in 2008-2009 prior to Honorable Mabe's appointment to Parliament is thus outside the scope of the committee. The allegation that Honorable Mabe benefited from the award on the contract by PRASA to produce Hamanati and Koala Express in 2012 occurred prior to Honorable Mabe's appointment as a Member of Parliament and is thus outside the scope of the committee. On the disclosure on financial interests related to KGB Media, Honorable Mabe did disclose his directorship in 2014 before his resignation as the director of the company. The Kellybone Mabe Trust, which holds the copyright to Hamanati and Koala Express, is disclosed on the 2015 disclosure of interest. On the matter of benefit being received by the renewal of the contract by PRASA with KG Media in 2015, the registrar notes that the Kellybone Trust holds 100% of the shares of KG Media. Honorable Mabe is a trustee, and the trust and the beneficiaries accordingly benefited from the proceeds of the contract. Honorable Mabe submitted a letter of appeal in which he indicated that he was erroneously disclosed that he is a beneficiary of the Calibon Mabe Trust and that it is in fact his minor children who are the beneficiaries of the trust. In view of that, the Joint Committee, that the legal custodian of the minor children, Honorable Mabe, benefited from the contract. Alternatively, Honorable Mabe's children benefit from the same in contravention of Section 6.2 of the Code. The penalty, in terms of 10.7.7.2, the Joint Committee imposed the following penalty on Honorable Mabe: a reprimand and a fine of 15 days' salary.
Yes, we are presenting the three.
Thank you.
And you have some 6 minutes remaining.
Non-disclosure of interest, Honorable Ghana. The complaint was based on the media report that Honorable S.M. Ghana failed to disclose sponsorship received in support of the campaign of the federal chairperson at the 2015 electoral conference of the Democratic Alliance, in brackets DA. Registration and replacement of, as the 25th of May 2017, now Mr. Ghana, DA National, resigned with effect from the 14th of November 2016. As Mr. Ghana resigned his membership of the National Assembly, the Joint Committee does not have any jurisdiction over him, and he is no longer a member of Parliament. Finding, in light of this above, the Joint Committee report to the National Assembly that they cannot proceed with the complaint against Mr. Ghana as the lack of jurisdiction over him due to his resignation. Report on the ethics and members' interest on alleged breach of the Constitution dated 14th of June 2017. The Joint Committee on Ethics, Members' Interest, received a complaint by Honorable Steenhuisen in which he alleged that Honorable Mabe breached the Constitution by being sworn in as a councillor without resigning from Parliament and assuming a seat in the National Assembly without resigning as a councillor. Mabe. The complaint alleged that by so doing, Ms. Mabe breached clause 4.1.1, 4.1.2, 4.1.3, and 4.1.4 and 4.1.5, the Code of Ethical Conduct and Disclosure of Member Interests. Clauses 4.1 of the disclosure deals with the standard of ethical conduct and provides the following. Members must abide by the principles, rules, and obligations of the Code. By virtue of the oath and affirmation allegiance taken by the elected member, uphold the law. Act on all occasions in accordance with the public trust placed on them. Discharge their obligations in terms of the Constitution by Parliament and the public at large, by placing the public interest above their own interest. Maintain public confidence and trust in the integrity of Parliament and thereby engaging the respect and confidence of society needs to have in Parliament as its representative institutions. Honorable Mabe requested an extension to respond to the complaint, which extension was granted. On the 13th of October 2016, Honorable Mabe responded to a complaint. In her response, she advised that the same complaint was raised by the complainant in the National Assembly for the ruling of this matter. Further, that she and her party was waiting the ruling of the National Assemblies. Consequently, she was unable to respond to the complaint. A report was obtained by the National Assembly, and the following was apparent. At a joint sitting of Parliament on the 25th of August 2016, and at subsequently sitting of the National Assembly, various members of the Assembly raised points of order regarding the validity of a membership of Honorable Mamba. The relevant presiding officer sought legal advice before ruling on the matter. The letter dated 13th of September 2016, addressed to the Speaker, Honorable Mamba wrote to the Speaker regarding her membership of the National Assembly. In the said letter, she advised that she has been nominated to serve as a mayor in Mokala City by her party, and because she was committed to the decision, she assumed office in Mokala City. She further stated, in the midst of all this, it is quite apparent that an important administrative error was committed in that my registration as a member of parliament was not rendered. Honorable Mama stated that she had no intentions of retaining dual membership as a councillor and a member of the National Assembly. A legal opinion on the matter was apparently sought and obtained, and Advocate Wim Trengrove SC, the legal opinion could thus be summarized as the following. Section 158(1)(b) and 158(2) of the Constitution read together means that the member of National Assembly may be a candidate of election or appointment to a municipal council, but may not hold dual membership on both the National Assembly and the municipal council. Further, in terms of the section 47(1)(b) of section 47(3)(a), the Constitution, a member of National Assembly loses his membership if he or she becomes a member of a municipal council, was member of the National Assembly, and thus loses membership occurs automatically by the operation of the law.
Can you try to deal with the last summary of your last report? Because it's not necessary that you have to go through everything, but you have to deal with the summary of it.
Yeah, and the last report I have is quite a lengthy report as well, and this is a report on the late disclosures that of members that have disclosed their members' interest forms late. And it's quite a long report, Chair. Can I table this report?
Thank you. Thank you.
Thank you very much.
Honorable members. That concludes the debate. I shall now put the question in respect of the first order. There were three orders. We are going to be dealing with the first order. The question is that the report be agreed to. As the decision is dealt with in terms of section 65 of the Constitution, I shall first ascertain whether all delegation heads are present in the chamber to cast their votes. In accordance with Rule 7.1, I shall first allow the opportunity to provinces to make declaration of votes if they so wish. Shall now proceed to voting. Eastern Cape.
Eastern Cape support the report.
Free State.
Free State support, Chair.
Gauteng.
Gauteng agrees.
KwaZulu Natal.
KwaZulu Natal iyavumelana.
Limpopo. Mpumalanga.
Mpumalanga iyaseka, Chairperson.
Northern Cape.
Northern Cape agrees.
Northwest.
We agree, Chair.
Western Cape.
We agree.
9 provinces voted in favor. I therefore declare the report agreed to in terms of section 65 of the Constitution. I shall now put the question in respect of the second order. The question is that the report be agreed to. I shall, in accordance with Rule 7.1, I shall allow provinces the opportunity to make declaration of vote if they so wish. Then we'll just proceed to voting. Eastern Cape.
Eastern Cape agrees, Chair.
Free State.
What, Chair?
Gauteng.
Gauteng agrees.
KwaZulu Natal.
KwaZulu Natal iyavumelana.
Limpopo,
Limpopo ra dumellana.
Mpumalanga,
Mpumalanga, it's support, Chair.
Northern Cape,
Northern Cape supports the report.
Northwest,
Agree, Chair.
Western Cape.
Agree, Chair.
9 provinces voted in favor. I therefore declare a report agreed to in terms of section 65 of the Constitution. I shall now put the question in respect of the third order. The question is that the report be agreed to. I shall first allow provinces declaration of vote if they so wish. We proceed to voting. Eastern Cape,
Eastern Cape yavumelana Chair.
Free State,
Free State iyadumela Chair.
Gauteng,
Gauteng agrees.
KwaZulu-Natal,
Iyavumelana.
Limpopo,
Dumellana le pego.
Mpumalanga,
Mpumalanga, support, Chair.
Northern Cape,
Northern Cape agrees.
Northwest,
We accept, Chair.
Western Cape.
Agree, Chair.
9 provinces voted in favor. I therefore declare the report agreed to in terms of section 65 of the Constitution. Order, honorable members, we now come to the subject of discussion as printed in the order paper. You are welcome, Honorable Minister Davis. I invite you on the, sorry. You are welcome, Honorable Davis. You are welcome, Honorable Davis. Our Minister of Trade and Industry. Honorable Mtimunye will open the debate. Honorable Mtimunye.
Thank you, Honorable House Chair. I hold no ambition to become a minister, rather do I want to become a proxy to Minister Davis. Honorable House Chair, the African National Congress has observed that apartheid South Africa had very poor records of consumer protection and much needed to be done in this area. Consumer protection is an important matter which requires urgent attention to shield people of our country from unscrupulous business practices. It is for these reasons that the ANC-led government has introduced legislation whose object is to protect the rights of consumers against unlawful and unscrupulous business practices by credit providers and employers alike. Banks in South Africa process approximately 56 million debit orders a month, and from these, close to 1 million interbank debit orders, including non-authenticated early debit orders, and these are disputed every month. The dispute ratio of non-authenticated debit orders is between 4.5% and 6% according to FIN24. Some of the victims of the unlawful deductions indicate that even if they get their money back, the banks continue to charge them for processing their debit orders. This may raise an argument that the unlawful debit order deductions seem to be profitable to the banks. It will seem that the banks do not have measures in place to detect unlawful deductions. Madam Honorable House Chair, South African Social Security agents, the South African Social Security Agency reported in 2016 that it has received 40,000 queries of unlawful deduction in February alone. Most of these deductions were related to cell phone airtime. This problem was prevalent in all the major cell phone network operators. A ministerial task team was established on deductions to curb illegal, immoral, and unauthorized deductions of social grants. This matter must be of serious concern to all of us as it works against the resolve of the democratic government to provide social security to the most vulnerable in our society. The elderly, people living with disability, young and old, and these people survive on these particular social grants, Honorable Chair. There is a high report of incidences of 99 rand scams where our people experience deductions of 99 rand from their bank accounts on monthly basis. Unscrupulous marketing companies are reportedly making these unlawful deductions, depriving our people the pleasure of enjoying their hard-earned income. Again, on this matter, the banks could not detect the unlawful deductions. The turning point on this issue of unlawful deductions, Honorable House Chair, by employers was brought to light by the Stellenbosch Legal Aid Clinic in the case of Stellenbosch Legal Aid Clinic and others versus the Minister of Justice and others. This was the matter where the applicants were subjected to unlawful deductions by their employer as a result of emolument and garnishing orders of the court issued against them. The court found, among other things, that the constitutional right of access to court for the applicants was violated. The right to access the courts is fundamental to the rule of law in the constitutional democracy. The respondents obtained judgment and emoluments attachment orders against the applicants in a court far from their homes and in places they could not reach. The court ruled that the right of access to court was seriously jeopardized if not effectively denied. The court further found that the whole process of obtaining emoluments attachment orders was driven by creditors without any judicial oversight whatsoever. This case led to the Department of Justice and Constitutional Development drafting a new Magistrates Court Amendment Bill in a bid to curb illegal garnishee orders. Our democratic government has over the years developed legislation to protect the rights of consumers. The Constitution of the Republic, in the chapters on the Bill of Rights, provides for the right to privacy, which includes the right not to have the privacy of their communications infringed upon. In addition, the right to administrative action that is lawful, reasonable, and procedurally fair. The many incidences of unlawful deductions by credit providers and employers in the contrast to the above-mentioned constitutional imperative. Our people as consumers enter into credit agreements which binds them to provisions which allow the credit providers to share their information with their business partners. This happens because the information leading to signing a credit agreement may not have been made simple and understandable to the consumer prior to the signing of the agreement. As found by the University of Pretoria research, some consumers are made to sign blank pages as part of their credit agreements. The Basic Conditions of Employment Act provides that an employer may not make any deduction from an employee's remuneration unless subject to subsection 2 of the Act. The employee in writing agrees to the deduction in respect of the debt specified in the agreement, and B, the deduction is required or permitted in terms of a law, collective agreement, a court order, or an arbitration award. These provisions seem to have been violated in the majority of the incidences, as was confirmed by the Cape High Court judgment. The issues which arise out of these observations is that banks must play a proactive role to save our people from unscrupulous and unlawful deductions by credit providers and employers alike. There is a need for a concerted awareness campaign about consumer rights by government, credit providers, as well as banks to educate consumers about their rights when entering into credit agreements. The banks must engage with a view to develop mitigating measures against this unscrupulous behavior by credit providers and employers alike. I thank you, Chair.
Thank you. Thank you, Honorable Mtimunye. The Honorable Minister of Trade and Industry, Honorable Davis.
Thank you very much, Chairperson, and thank you to the Honourable Mutimunye for raising this matter and this debate. Let me say that I'm mostly going to focus on attachments of salaries, emoluments, orders, and the like. Some of the other practices that he mentioned, I will take back and ask our Consumer Commission to investigate as well, because I think these are critical matters. So let me start by saying that I think that we should all understand that credit is a means of enabling people to make purchases of items that they can't afford to pay the full cost of outright, but can afford them if they're able to make the payment over a period of time. It's a critical tool of commerce. It enables purchases of various items of a consumer durable nature. But of course, we are operating in a society driven by profit, and that means that these facilities are not made available for free. There's also a considerable imbalance between many of the credit users and the credit providers in favor of the credit providers, which means that the credit providers are often able to extract extortionate terms out of those who need and depend on credit. Now, it's for that reason that we have in South Africa taken the view that this needs to be a regulated activity. There was a pre-existing Usury Act in force in South Africa before 1993. That was subject to revision and review, and it became changed into the National Credit Act, which gave rise to the establishment of the National Credit Regulator, and that act came into force in 2005. And the Credit Act seeks to regulate the conduct of credit providers in a number of ways. First, by setting ceilings on the credit levels that can be charged. In addition, also the various associated fees, which are often the way of wiggling out of ceilings on interest rates. Secondly, it is intended to act against reckless lending. The provision of credit to low-income people without taking any account whatsoever of their ability to afford it or of the impact of that credit on the lives of those people. Now, you might ask, why would anybody want to provide credit to somebody that can't afford it? It is, in fact, not irrational. If you can turn that credit into a security and you can sell that security to somebody else, which is what happened in the United States, and there's something called light touch regulation, you can find that a huge bubble can be created in, for example, property. And people thought they were buying property securities. Probably many people thought they were buying the underlying property asset. They were simply buying the right to receive the mortgage payments of people who the prime lender had no interest in capping the number of, because they could sell it on and pass on the risk. That was what happened. And so it's not just that it is damaging to the individuals, it also is damaging to the system, creating a bubble, creating, in fact, a world global financial crisis in 2007-8. In our own country, we didn't have so much of that, but what we do have is we have reckless provision of credit to low-income people, and then that is mitigated by ensuring that those people, the deductions happen. In the first instance, it was by holding people's bank cards, IDs, and ensuring that when payday comes, you go into the ATM and deduct before the person gets it. And then when that was banned, then there were these garnishee orders and various facilities that meant that very often people were leaving work with their pay packet and they were getting some insignificant proportion of their total salary. Now, of course, that has an impact on the people concerned, but it also has an impact on social relations. So let me give a concrete example. At the time and just after the tragedy in Marikana in 2012, the National Credit Regulator went to Marikana and they found there were 13 credit providers, 9 of whom were not in fact compliant with the National Credit Act, and many of the workers there had 80–90% of their salary encumbered in debt repayment purchases through the garnishee order system. And so under those circumstances, well, you know, a salary increase of CPI plus a bit doesn't crack it. Your financial circumstances doesn't change unless there's a dramatic and fundamental change in your income situation. Now, where are we in South Africa now? We have, according to the figures I've received from the National Credit Regulator, there are 24 million credit active people in South Africa. The total volume of credit that is deployed in South Africa is 1.7 trillion rand, which is something like a third of the GDP. Now, of those 24 million people that are credit active, around 41% of those are what are called stressed. Now, that doesn't mean that you are subjectively feeling stressed about your credit situation. It means you have not made your credit payment for 3 months. You're in arrears, in other words. You've got a judgment against you, or you've got an adverse listing in a credit bureau. So it's an objective assessment. That's 41 people. That's about 10 million odd South Africans who find themselves in that situation. Now, given that you're not allowed to get credit until you are 18, and that we have a very young population, that's probably about a third of the adult population of this country who've got a stressed credit record. That's the situation that we're in. And so I think that what we have been doing, and it's always a moving target, is to address, well, one, the interest rate ceilings and the charges. Secondly, we've been addressing the question of basically we gave a credit amnesty, or credit bureau amnesty rather, and that was on the initiative of this House at the end of the last term, where people's records in the credit bureaus were cleaned on a one-off basis. Because we said that people who were in that position were there for life, unless you made an extraordinary effort to get yourself off. And if your circumstances changed, that didn't change. And that also meant that what was happening was that credit providers were not actually undergoing and undertaking an affordability assessment. And so they were handing out this credit, and often the tool that they were deploying was the garnish your order or the deduction at source, so that you never saw it in your salary. And all kinds of devices were there, including, of course, that was what you signed off for when you got the credit agreement in the first place. Now, I think we've seen that this is a seriously undesirable situation. At one stage, there was a significant part of the public servants who were subject to this situation. And so what we've been doing is through some of the legislation that the Honourable Mtamunya mentioned just now, but in particular the Courts of Law Amendment Act of this year, there is now a cap on what are called emolument attachment orders. And the emolument attachment order can now no longer exceed 25% of an individual's salary or wage bill. These orders have to be issued in a court where the consumer lives or works. They must be presented to a magistrate, and the consumer must appear before a judicial officer, not the clerks at the court. And then the magistrates can assess the validity or otherwise of claims for such orders. So there's a limit and a cap on these orders. But there's also other work that's going on. As the Honourable Mtamunya mentioned, through SASSA and the ministerial team on deductions, to make sure that deductions are not taking place, airtime, electricity accounts, and all sorts of other matters before the individual receives their payments. And then there is work going on led by National Treasury to review payments, the Payment Systems Act and payroll deductions and garnishee orders more generally. And I think that this is something that we all need to support. But also I would suggest that, and I think that in the way I responded to the first set of points, I think we need members of parliament to be telling us, where is this not happening? Where are we seeing that people are being subject to deductions from payrolls which are beyond the 25% limit? Why is this happening? Let us know about it, and we can ask the National Credit Regulator to follow up on these cases, because it is now no longer legal in this country. Let me mention one other thing that's happening. I said that this House had spearheaded the Credit Bureau amnesty. We've got a situation now where I think if you look at the figures I gave earlier on of the level of indebtedness in this country, If you start translating that down into income categories, and I haven't been able to get that information, but I'm sure we can all understand that that must include people who are unemployed, people who have no income, people who have no assets. And I think that there are clearly people who are not going to be able to service a debt any longer. And the National Assembly and the Portfolio Committee will be publishing a bill, I understand, next week, but it's their call, a bill for public comment, which will be seeking some sort of an amnesty for the people who are subject to that debt. I think we want to call on credit providers to understand that this money is not going to be repaid. It can't be repaid. It's a millstone around the neck of people whose circumstances are extremely stressed. There are many countries around the world that have embarked on this exercise, particularly for what are called NINAs, no income, no asset people. And I think that this is something which we need also to support. So let me say that I think that while access to credit remains important, while we want to ensure that people are able to purchase things other than the things they can afford this month over a longer period of time, we also need to make sure that this happens in a responsible way that does not result in preying on low-income people, predatory credit practices, and there are plenty of those around. And I think the other experience is that we were partly spared a systemic financial crisis because, among other things, we had the National Credit Act in place, and right after the financial crisis, there was a considerable amount of interest internationally in that act. We need to make sure that the Credit Act is effective in protecting people, and also that I think this is something that the Financial Services Board and other parts of the market conduct regulatory family ought to be dealing with, that where people are subject to an illegal deduction and it's subsequently reversed, there should not be a payment. They should reverse the payment as well. And I think that we would be more than happy to hear any details of that and to pass that on to the National Consumer Commission as well. Thank you very much.
Thank you, Honourable Minister. Honourable Lond.
Thank you, Chairperson. Thank you, Honourable Magwebu. I really appreciate the welcome. Honourable Chairperson, Honourable Minister, honourable members, the topic for today's debate is extremely relevant to the current day South Africa. It is a situation faced all too often by hundreds of thousands of workers in all sectors, all areas, all ages, and all races. It also affects millions of unemployed South Africans on a daily basis. It is our responsibility as lawmakers to ensure the necessary legislation is in place to protect our workers and also to protect the millions of consumers who buy on credit on a daily basis. I'm satisfied that on this issue, we do have a common goal that we want to achieve. The debate today could easily have been divided up into two parts. The first focusing on those who have, and the second on those who have not. Those who have a job are blessed to use their skills, their knowledge, their abilities to look after themselves, their families, and their loved ones. For the haves, it is pretty clear when employers may or may not deduct money. And the Minister touched on many of that. So, Minister, thank you for shortening my speech somewhat. But I do want to raise some of the points that the Minister did not touch on. Firstly, an employee must be responsible for the damages and the losses that he or she caused. That is clear. The responsible person who caused the loss or damage must then be held accountable. It cannot be attributed to a group or to all the workers. It must be the individual that gets held accountable. As the Minister said, an employer may not deduct more than a quarter or 25% per pay run. The employee must also give that written consent. It cannot just be a one-sided action that gets taken by the employer. And the employer must also just deduct the actual loss. There may not be any penalties. In certain instances, interest may accrue. But that is pretty straightforward. The issue that I want to touch on is all of those who have, those who have the opportunity to provide for their loved ones must be protected, and they must not be the target of predatory credit providers. Those who prey on individuals who are in a vulnerable situation, provide them with a quick escape when they in fact get themselves into bigger trouble. There should be some critical questions we must ask ourselves. The first of these questions is, how is it possible that so many South Africans get into a situation where they owe credit providers millions, if not billions, often way beyond what they can afford to repay, forcing thousands into a crippling debt spiral, unable to get out of the cycle and start building their own financial security? The education of South Africans in personal financial management should start at a young age, where the value of money is better explained, understood, and appreciated. The risks surrounding reckless lending and the real cost of repaying loans should be taken into consideration before people fall into the debt trap. But this is an education issue that we should start at a young age. This should be in fact taught at schools, in communities, and must become second nature for South Africans to work more wisely with their money. Luxuries and treating ourselves should only come after the essentials are looked after. It is unacceptable that parents and guardians would rather buy alcohol, cigarette, branded clothing, luxury items, yet kids go to bed hungry. There should be a joint responsibility by government and every individual to work better with the limited funds available in this country during this tough economic climate. Honourable colleagues, honourable members, there is, however, a much bigger question and a problem. Although what we are discussing today is extremely important, there are millions of South Africans, in fact close to 10 million, who are currently unemployed. They do not have a job. They are the have-nots, as I referred to above. People who should be given the opportunity to earn a living wage and look after their loved ones. The economic growth we are currently experiencing will never be enough to address the crippling unemployment we are facing in this country. There needs to be a radical change in our approach to how we are doing business, how we are treating businesses, and how we are supporting businesses. I'm not talking here just about the big businesses, because although they must do their share in lifting millions of unemployed, it cannot be just their role and their job alone. It cannot, I repeat, it cannot be the job of government to also provide the millions of unemployed the opportunity to do the job. Government is incapable of doing that. It is the responsibility of government to create an enabling environment to look after the millions of potential entrepreneurs out there so that they can then be the job creators for South Africa. It is time that every single one of us start focusing on supporting the thousands of potential entrepreneurs we do have. The entrepreneurs who have a dream of providing for their family. The entrepreneurs who have a dream of providing jobs for other South Africans. Because it is only through them being able to achieve their success and their goals that millions of unemployed South Africans will also be lifted out of this debt trap that they are facing and that they are stuck into. The role of government should be the enabling environment to provide political stability, clear policy direction, corruption-free governance, and inspires the confidence that the hard-earned money of investors, of those working for it day in and day out, will not be put at risk by self-serving political decision-making. It is our responsibility to look after every South African so that we do not have to talk about the have-nots in the country anymore. I thank you.
Thank you, Honorable Lond. Honorable Makue.
Thank you, Honourable House Chair, the Minister, Honourable Rob Davis, Honourable Members. The overarching purpose of the National Credit Act, number 34 of 2005, is to promote and advance the social and economic welfare of South Africans by, amongst others, protecting consumers from unfair conduct from credit providers. The unlawful deductions by credit providers is one such unfair conduct. The promulgation of progressive legislation is also not an end in itself. Education and awareness of and compliance with laws are imperatives. For workers and consumers, especially the poor and vulnerable people, the National Credit Regulator and National Credit Tribunal has been established by this government. The National Consumer Tribunal and the National Credit Regulator, which is responsible for the regulation of the South African credit industry, are entities of the Department of Trade and Industry. During the current financial year, the Department of Trade and Industry, in collaboration with its regulatory entity, the National Credit Regulator, has conducted education and awareness campaigns in the following 7 provinces, namely Limpopo, KwaZulu-Natal, Eastern Cape, Mpumalanga, Northern Cape, Northwest, and Free State. Further education and awareness campaigns are scheduled to take place in the Western Cape during the month of November, that's this month, and in Gauteng province during February of 2018. The National Credit Regulator, working jointly with local tribal authorities in rural areas of most provinces, conducted community outreach programs, or what we call imbizos in the ANC, aimed at mainly pensioners to create awareness relating to their rights and responsibilities as consumers in the credit industry. The NCR tells us that the repeat visits will be made to all these provinces. Under the National Credit Act, the DTI has amended and implemented a whole number of legislation. The National Credit Amendment Bill that Minister Davis referred to earlier is also something that the Portfolio Committee of Trade and Industry within the National Assembly is developing this year. Proposals of this draft bill are to provide debt relief measures to reduce the impact of high over-indebtedness for certain over-indebted households in the severe economic circumstances in which we in South Africa and the world find itself. Secondly, criminal prosecution for contraventions of the National Credit Act 2005, for punishment and deterrence for unlawful conduct by credit providers, and redress, for example, banks and other lending institutions for reckless lending to consumers are being considered in the draft proposals. Let me provide an example of the deductions that were made on a person's salary, that are made, and how the NCA, the National Credit Authority, is dealing with it. The National Credit Act, sorry. We have what we call the unlawful set-offs. In the matter that was launched by the National Credit Regulator against a registered bank, a consumer complained to the National Credit Regulator that he became unemployed for a year and duly informed his credit provider about his predicament. He subsequently became employed again, earning a salary of 5,000 rand per month. When he got paid at the end of the month, this bank deducted 3,863 rand from his account, where he earned 5,000 rand, which money was meant for groceries and school fees. So it's right. When we see these atrocities, it is increasing poverty. In another example, a consumer complained again that the same bank deducted money from his savings account without prior notice or authorization as required by the National Credit Act. Both these unlawful deductions prejudiced the consumers. The National Credit Regulator, as well as the National Credit Tribunal, successfully intervened on these matters in favor of the workers, thus setting a legal precedent. However, the banks continue to apply the common law principle of set-off on accounts opened after the 1st of June 2007. Despite the provisions in the National Credit Act, this may all change with the announcement by the National Credit Regulator that it has brought an application against a bank in the North Gauteng High Court to obtain legal clarity on the effect of Section 124 of the National Credit Act of 2005 on the common law set-off. The NCR, National Credit Regulator, is seeking an order from the High Court that the common law set-off has been superseded by Section 124 of the National Credit Act. Chair, enough has been said about the unlawful cards and the retention of people's pension cards and their PINs. In spite of Section 91 of the NCA stating clearly that it is unlawful for a credit provider to retain possession of a consumer's bank card or identity document. Since April 2017, a total of 3,084 bank or SASSA cards have been seized from various credit providers after the National Credit Regulator conducted raids in the Gauteng, Limpopo, and Mpumalanga provinces. In addition, a total of 17 persons were arrested for these unlawful bank and SASSA card PIN retentions. In the previous year, that's 2016, raids were conducted in Gauteng, Free State, Limpopo, and the Northern Province. Bank cards, PINs, and ID documents were retrieved, and a number of credit providers were arrested. This is the work that is being done by institutions established by this government to protect and promote the best interest of the poor people of this country. The National Credit Consumer Tribunal derives its mandate from the National Credit Act, and as such, hears all sides of a case before making a decision. A decision by the National Credit Tribunal has the same status as one made by the High Court. And we want the consumers out there to notice this, to hear the message that there are authoritative powers that this government has given to the institutions that are promoting the interests of the consumers. We, in the National Council of Provinces, encourage consumers to be cautious when engaging in credit agreements. Should consumers feel aggrieved by credit arrangements, and especially when consumers are unable to service their debts, they are at liberty to approach the National Credit Regulator for assistance and advice. We call on people to desist from borrowing and on making loans from loan sharks and illegal credit bureaus. We all have the responsibility to report such illegal activities to the National Credit Regulator. And in this way, we will be creating a better life. I thank you, Chairperson.
Thank you, Honorable Makua. Honorable Kone.
Ke a leboga modulasetilo. Ke dumedisa South Africa ka bophara. Go utlwisa botlhoko gore di-membera ka bontsi tse di tlile go bua mo ke di-membera tsa ANC tsone tsewa tse di leng mo governmenteng. Ba tlile go ema mo ba re rasetse ya ka re ke dipidipidi ba le mo governmenteng. Bone as government ba dira eng or ba dirile eng so far since ba kry-a gore go na le bothata bo re tshwaraganeng le bone gompieno mo. Let us begin by making a fundamental, often misunderstood, and important clarification. It is incorrect to say it is unlawful deductions. What is happening is stealing, it is thievery, it is greed. And given the blood-sucking nature of capitalist system, this is what we must when profit matters over all else. Majority of the so-called credit providers are not legitimate businesses, but fake service providers who operate under the pretense of selling one financial product or other services. Majority of the so-called credit providers, all they do is prey on the workers and take advantage of a banking system that is designed to exploit workers and steal from the very little that they earn. But most importantly, majority of these so-called credit providers are in collusion with banks, and it is banks that make such illegal deductions possible. Banks are not bothered by the stealing, thieving, and greed that is going on with these 99 Rand deduction schemes because they make profit when the deduction happens, and they make profit when deduction is reversed. For banks, the more deductions for the banks, the better. While the stealing, thieving, and greed that happen at a very small scale, if one adds all those 99 Rand together, stolen from thousands of, if not millions, is millions and millions every year. The sad reality is that those who suffer the most are the workers, the poor, and social grants beneficiaries. Some of these deductions have in accounts that have nothing less than the amount of deduction, the only money left in the account. What is more concerning is that while we're debating the problem of deductions that steal money from customers' accounts, it is also a reflection of financial crimes that are happening in the financial sector, especially banking. Those with power and access are exploiting customers, exploiting their own workers, and exploiting gaps that should not even exist to begin with. As the EFF, we have proposed in the FICA bill and the Financial Intelligence Center bill that if there is an authorized deduction in customer's account, it must be the bank's responsibility. It must be the bank that pays the money back into the customer's account. It must be the bank that reports the matter to the police. It must be the bank that, through their lawyers, take the matter to court and make sure culprits are apprehended. It must be the bank that guarantees safety of customers' money because customers are paying premium price on banking fees for safety of their money. Unless banks are made to feel what customers feel, unless banks start losing some of their money, and unless banks do not make profit from these deductions, debating it here in the council will not solve the problem. And it is our people, the workers, the poor, and the social grants beneficiaries who will continue to suffer the most. It is unfortunate that the Hawks and the NPA are in permanent leave of absence and sleeping while lawlessness prevails. Other people are exposed to all sorts of crimes, and the law enforcement agencies are nowhere to be found. I've known Honorable Mutimunye for more than 2 years now, but since I've met him until to date, I've never heard him speak any sense, but today, unfortunately, he did, and I agree with him. Thank you very much.
Honorable Khai.
Honorable House Chair, Honorable Minister, Honorable Members, let me thank Honorable Timunya also for initiating this debate. Just to inform House Chair, the speaker before me, that the ANC is coming to lament that the ANC has actually done a lot with regard to addressing this matter. I will invite the honorable member to, when she has time, to read the Consumer Protection Act.
Honorable Khai, Honorable Kone, what is the point of order?
The point of order is from the matter that the speaker on the podium just referred to. Can he just mention two of the many that he's referring to? Just two things.
Honorable
Interventions, two interventions.
Honorable Kony.
From the many that he mentioned.
Honorable Kony, allow me to make a ruling. You know, take your seat. You know very well that is not a point of order. You are debating with the speaker on the podium. Refrain from doing that. Let's allow Honorable Lond.
Chairperson, I just want some clarity because it's now debate after debate after debate that people stand up on points of orders and it is seldom a point of order. What's the chairpersons or yourself as one chairperson going to do to start preventing that and making sure that there's actions against those that keep on raising frivolous points of orders?
Leaders of various delegation and parties must prevail to their honorable members in terms of making them to understand the rules. My role is to preside, and I've made a ruling that is not a point of order. Honorable High, can you continue?
Thank you very much, Honorable House Chair. I was inviting the Honorable Member when she has a time to read the Consumer Protection Act, the National Credit Act, Basic Condition of Employment Act, also the regulations on Social Assistance Act. Those documents at least will clarify what is it that the ANC government is doing to deal with the matter. But I also invite her to follow the process that are initiated by the Portfolio Committee on Trade and Industry on the debt relief bill. Honorable House Chair, for us as ANC, it is a situation of what the ANC normally called many voices, one message. You will find that the message that we are taking out there to the communities is one. In preparation for the inevitability of assuming the responsibility to lead a democratic South Africa, the African National Congress in 1992 developed a document called Ready to Govern. In that document, among other things, the ANC outlined that the democratic state will introduce mechanisms to encourage private sector financial institutions to channel resources into productive investment, the development of basic needs sector, and to end discrimination in lending against blacks, women, and informal sector or very small-scale producers. The point of discrimination in lending against blacks, women, and informal sector or very small-scale producers led ANC government to introduce legislation which will protect the rights of consumers, among other things. The preamble of the Consumer Protection Act 68 of 2008 states that the apartheid and discriminatory laws of the past have burdened the nation with unacceptable high levels of poverty, illiteracy, and other forms of social and economic inequality. Therefore, it is necessary to develop and employ innovative means to, among other things, protect the interests of all consumers, ensure accessible, transparent, and efficient redress for consumers who are subjected to abuse or exploitation in marketplace. The question of unlawful deduction by credit providers and employers is a serious concern. This issue is in large measure occur as a result of, among other things, emulent and garnishee orders by our courts and magistrate courts. There are many court cases where emulent and garnishee orders have been found to be unlawful. For example, the Stellenbosch case. According to a research done by the University of Pretoria in 2008, the one that Honorable Mtimunya referred to, titled The Incident of and Undesirable Practices Relating to Garnishee Orders in South Africa, reports that there were 16.9 million active consumers at the end of 2007, September. And these 6.3 million of, or 37.7% had an impaired credit record. In May 2007 alone, 105,427 summonses were issued for debt and 54,755 judgments granted. The research report went further to indicate that in some cases, which involve what we could argue to be unlawful deduction, the research found that the debtors averred that they never signed consent to judgment, even though judgment was granted on such basis. In some instances, the debtors alleged duress or misrepresentation. Cases of blank consent, incomplete documentation, and forgery of signatures are reported on. The research also found that unlawful and burdensome charges are added to the capital amount of the original debt in numerous cases. This shows that our people are taken for a ride by these credit providers and debt collectors. In 2016, following the reported unlawful deduction, mostly by cell phone network companies, the point that also Honorable Mtimunye referred to, which were unlawfully deducting airtime from old age pensioners, depriving our pensioners, who are the most vulnerable in society, their social grant provided by this government for their own livelihood and sustenance, depriving our social grant beneficiaries their little income and therefore subjecting them to poverty. In response to this inhuman practice, the Minister of Social Development published a revised regulation to the Social Assistance Act. According to the minister, these were unauthorized and unlawful deductions. Among the measures outlined by the minister to deal with these acts of criminality includes 24-hour, 7 days a week toll-free to report suspicious and unlawful deductions among SASSA beneficiaries, to provide on-site SASSA commissioners of oath to assist in completing dispute forms, as well as a team of SASSA officials to deal with deduction disputes. These unlawful deductions among SASSA beneficiaries stand in contrast to our policy as ANC of implementing a comprehensive social security net to provide a targeted and impeccable approach to eradicate poverty and unemployment. Unlawful deduction on consumers by credit providers and employers negatively affect consumers' personal disposable income. The logic of economics is premised on demand and supply principle, where producers produce goods and services to be sold to consumers in market. This logic reflects two sides of the same coin. Economic growth requires the continuous interaction of demand and supply. This exchange of goods for income is dependent upon consumers' disposable income. If the consumer's disposable income is unlawfully reduced, as in the case of unlawful deduction, the demand for goods and services will decline, leading to productions without sale and ultimately recession. The Public Service Commission undertook a study on the indebtedness of public servants in 2007. The relevance of the research by Public Service Commission is in relation to the impact of unlawful deduction in the form of emolument and garnishes orders on the economy in general and productivity in particular. The report found that these emolument and garnish orders create an administrative burden on the public service, as these orders must be implemented by the public service through its PESA. This means that some public servants will endure the responsibility of implementing the orders, and this takes them away from their employment responsibility. There are associated health risks due to financial distress. The published research by Consumer Interest Annual indicates the relationship between health and personal income. The research argues that financial difficulties are among the known causes of stress and anxiety. The Public Service Commission sick leave trends listed depression or stress-related illness to be among the top 5 illnesses that resulted in the highest number of days of sick leave taken in public service during 2002. Again, productivity is also affected due to ill health, absenteeism, and poor performance. This affects state's capacity to deliver on its promise of better life for all. Other effects relate to the issue of double employment with the hope of raising income.
Honorable Hai, I'm afraid your time has expired.
Thank you.
Honorable Kaula.
Ngiyathokoza sihlalo ngibingelele kumhlonishwa uNgqongqoshe egameni leqembu lenkatha yenkululeko ngiyathokoza ukuba ngibambe iqhaza kulesi sihloko esibalekile esimayelana nokukhula kwezinga lokuqolwa kwabantu bakithi ngokubanjwa ngokungemthetho kwezimali zabo. Lona umkhuba omubi kakhulu futhi ubugebengu okufanele uhulumeni enze indlela yokuba kusondele umnyango wamaphoyisa kulobo bugebengu ukuze buqedwe. Abantu izikhathi eziningi bazifumana sebekhokhela izikweletu zezinto abangakaze bazithathe enhlobo. Kuyenzeka kube nomuntu obanjelwa imali kwi-account yakhe yebhange ngento angayazi. Kokunye umsebenzi abanjelwe imali yakhe nge-stop order emholweni wakhe ngento angayazi nhlobo. Kokunye umuntu azifumane nomshwalense wakhe noma umshwalense wendlu noma umshwalense wemoto kodwa engakazi nakancane abe ingxenye yokuxoxa lowo mshwalense. Angisayiphathi ke sihlalo eyomkhulu nawogogo lapha ezimpeshenini zabo ngoba sebeqothuliwe ile mikhuba bajoyiniswa omasingcwabisana abangabazi bakhokhela ama-airtime abangawazi bakhokha izikweletu zogesi abangabazi. Indlela lobu bugebengu obenzeka ngayo ikhomba ukuthi kunokuxhumana okukhulu phakathi kwamahhovisi asayinela ukuthathwa kwezimali kanye nalezo zigebengu ezisuke ziletha amaphepha asayinelwe ukuba kuthathwe lenkece. Kungako sihlalo iqembu lenkatha lithi uma lo mkhuba ungasukunyelwa ngabezomthetho bese kuboshwa bonke labo abathintekayo kusho ukuthi usazoya kude. Kwesinye isikhathi kuthathwa lenkece yakho ungazange ugunyaze lutho. Uma usuya ebhange uyovula uyocela ukuba bavimbele imihlola bakutshena ukuthi hamba uyoxoxisana nalapho kuya khona inkece ngoba bona ngeke bayivale bengagunyazwanga ilabo bayithathayo. Lona umhlola oxaka ukwenza ngoba kuthiwa angiyoxoxisana nesigebengu ukuba sivume ukuba ukungabe sisayithathe inkece yami. Ngiyafisa ukudlulisa ukuncoma kumhlonishwa umthimunye okunguye osinikezele isihloko esibaluleke kangaka esikhuluma ngezinto ezibakhathaza ngqo abantu sibamele. Omunye umkhakha wabantu abahlukumezeke kakhulu ngalolu hlobo lokuqola abasebenzi bakahulumeni okuhlanganisa othisha, onesi, amahhovisi njalo njalo. Kukhulu kakhulu ukukhohlakala okwenziwa ngamaqili emholweni yabasebenzi bakahulumeni bona bengayinikanga imvume. Kunalabo abacuthela nje ukuthi uma beke baba ne-PESAL number yomsebenzi kanye nenombolo kamazisi hawu sekushile isihambile inkece ngoba usuthathelwe umshwalense obungazange ucele. Omunye umuntu engakuthatha kalula nje ukuthi uma kwenzeka lolu hlobo lobugebengu abantu abavuli ngani amacala. Kokunye sihlalo ukuvula icala uhamba nezinkantolo kukubiza inkece eningi ukwedlula lokho ukuthi uzama ukukulungisa. Kubiza nesikhathi sakho esiningi ngalendlela ukuthi abantu abayisulu zalomkhuba kabavamisile ukuba babe nomdlandla wokuvula amacala ngenxa lezi zizathu. Enye inkinga ukuba kakufinyeleleki kalula kulabo NCR okukhulunywa ngabo ikakhulukazi kubantu abasezindaweni zasemakhaya. Mhlawumbe iParliament kufanele ke libuke ukuthi kungebe nomthetho ophusile yini ukuba kube nomthetho oshawa yilo ozokwenza kube umqansa ezinkampanini zenkece ukuwaka abantu kalula nje. Nanokuthi uma inkampani yenza lo mkhuba isibanjiwe kuvimbana ukuba ifakwe ohlwini labangenzi kahle blacklisting ukuze iphelelwe igunya lokusebenza. Olunye uhlangothi noma umkhakha lapho abantu bakithi bebhubha khona ngokukhokhela izinto abangazazi ilapha ezinkampanini zomakhalekhukhwini. Kunabantu abahlale befona ungazi ukuthi izinombolo zabantu baziqoqa kanjani. Bafona nje banemininingwane yakho yebhange neminye. Kuba ukuluphendula nje ucingo kube ukujoyiniswa into ongayazi. Kufanele uphele lo mkhuba ukuthi uma unikeza imininingwane yakho ngesivumelwano osuke usenze kwenye indawo ebese idluliselwa nje kalula kunanoma ngubani. Yikho lokudluliswa kalolo kwemininingwane yabantu okuqhubezela phambili lobugebengu. Liyakhuza ke sihlalo iqembu lenkatha baphela abantu izitop order mbumbulu ake kufunwe amasu okulwa nalesihlava ngiyathokoza.
Atogos. Honorable Faba.
Los hy cell phone, yes. Okay. Thank you, Chair. Honourable Chairperson, members and fellow South Africans, this debate on illegal and unlawful deductions by credit providers and employers is welcomed. But first, Honourable Mutimunye and Honourable Gai, the ANC government is not succeeding to protect customers through the Consumer Commission, as this practice are still on the rise under this ANC rule. If the ANC were successful, we would not have this debate here today, to be quite honest. There are two basic words we should look at. What is illegal and what is immoral? In the Basic Conditions of Employment Act 75 of 1997, it's clear that employees may only make deductions on a worker or employee's salary if they agree in writing to the deduction or debt by a collective agreement, such as UIF or court-order deduction. And as the Minister also said, not exceeding 25% of the worker's pay. If not, this is illegal. In South Africa, there are more than 16 million pensioners receiving social grants, and 500,000 pensioners are affected by unlawful deductions, by ruthless loan sharks who charge high interest rates and repayments, deducting money from pensioners who receive just more than 1,400 rand per month by SASSA. To live on is both illegal and it's immoral, taking it from these elderly. Financial service providers have a duty not to provide credit recklessly, especially when selling life policies to elderly people and providing microloans to families, as these poor families then find it excruciating difficult to afford to put food on the table. This is not made easier by the fact that many more people are starting to buy food on credit, digging themselves a deeper credit hole. I believe that SASSA should play a leading role with community development workers or social services to help prevent these type of practices taking place. And harsh penalties should be installed to credit providers who take advantage of our elderly people. I believe that SASSA and these people should help exploit these illegal providers. Credit providers who keep up with these practices should be blacklisted and have criminal charges instated against them and prohibited to trade in the financial sector. Why don't government take more drastic action against these type of practices? If government act ruthlessly against these thugs, these practices would show a drastic decline. This should tell a story. Let's act and especially help our elderly and poor people from being exploited. I thank you.
Thank you, Honorable Faba. The Honorable Mtimunye.
Chair, I think Honorable Hatting must be called to order. He said I'm a liar.
Honorable members, refrain from anything that you know that has got nothing to do with the decorum of the House. Okay, Honorable Hatting. Honorable Hatting, let me first ascertain. Honorable Hatting, did you say Honorable Mtimunye is a liar?
Said,
no, I want Honorable Hatting to respond.
I said he should not lie again.
Just change English.
It will be attended accordingly. Can you continue, Honorable Mtimunye?
Thank you, House Chair. House Chair, just listen to this one. I came to home with 70 rand of my 1,140 rand, says a social grant beneficiary. This is a message I got from one of my sources. I will not reveal here. So at the center of this debate, Chair, is not just unscrupulous credit provision activities that are happening. it is a brutality of capitalism that we're dealing with here. Perhaps Honorable Pakis is correct that socialism is the way and socialism must be built now. The Honorable Minister make reference to the fact that 41% of the credit records are those that are referred to as stressed. And these, Chairperson, come in the main from your poor of the poorest that you have in this country. And I want to appreciate the fact that Honorable Lond agrees with me with certain reservations that these poor, the bigger chunk of these poor people are unfortunately black people who do not find themselves there out of their own wish or will, but they happen to find themselves at the lowest ebb of our economy because of the brutality of apartheid. Yeah. And these are the people, Chairperson, that Honorable Khai refers to, and these are people who are dying of diseases that are stress-related, caused by these deaths. And these are people who die of kwashiorkor, Chairperson, as opposed to dying of sugar diabetes, the disease of the rich. And so, Chairperson, this should suggest to us that this matter, the debate before the House today, it's no matter of political gimmick. It's a real matter that affects our people. Hence, we agree with Honorable Kaula. Another matter, Chairperson, that Honorable Koni make reference to, Honorable Khai responded to. And Honorable Koni wanted to have at least two things that the ANC government has done in addressing this problem. But Honorable Khai gave him 2 + 1, which is a bonus. But I think...
Honorable Koni, what is the point of order?
The last time I checked, Honorable Koni is a she. The honorable member on the podium says, Honorable Khai referred to him. He's not saying to her, I'm a she. Please,
No.
can he withdraw that?
No. No. The point of order is sustained. Honorable Mtimunye, Honorable Koni, it's a she.
I have corrected that from inside myself, Honorable Chair. Honorable Chair, the ANC government, over and above the legislation that it has put in place, it has also established organizations such as the National Credit Regulator that on daily basis deals with issues. These are some of the instruments that the ANC government has put in place. But I think Honorable Khai makes a reference to a very important point, that it is very important for members of parliament to be to be informed and be equal to the issues at hand. And for Honorable Koni to be so much ignorant of such an important matter when she comes from the party that claims to be belonging to the left.
Honorable Mtimunye, Honorable Koni, why are you standing? Honorable Koni, Honorable Mtimunye, can you take your seat while dealing with the point
Honorable Mtimunye must not underestimate my intelligence. He must not undermine me to that level. Yeah, he's not done. If he's not done, he's continuing. I will continue standing on point of orders to correct him because he's misleading the South Africans out there. So if he's taking this personal, so let's go toe to toe. It's fine.
Honorable Koni, that is not a point of order. You can't be debating with him at the podium. Can you continue, Honorable Mtimunye?
I think ignorance on the part of members of parliament, Chair, must be declared a crime against humanity. Honorable Chair, let me share with you some of the characters, among others, of a developmental state. And these are the things, among others, that the ANC government is doing. The ANC government intervenes in the economy. The ANC government levels the playing field, but But this playing field must also be understood in context that ours is an unequal society. And the ANC, therefore, should unapologetically be biased to the poor in its intervention. Honorable Famba, I make reference to the fact that the ANC is not succeeding in preventing the practice. But, Honorable Chair, I think the ANC government may not have done it all in this particular space. But the ANC would have done more in this space should it have not been the DA that represent and defend capital in this parliament. However, Honorable Chair, on behalf of the Office of the Chief Whip, I think I must appreciate...
Honorable Mtimunye, let me take Honorable Julius. Why are you standing?
Just wanted to know whether the Chief Whip will take a question.
I don't know whether I'm making a mistake.
Sorry,
You want to talk to
Honorable
the...
Mtimunye will take a question.
Okay.
You confused me.
No, thank you. Let me ask it. Honorable Mtimunye, are you ready to take a question from Honorable Julius?
Not from the representative of capital.
He's not ready to take a question.
Point of order.
Okay, Honorable Mtimunye, let me take the point of order. Point of order.
Chairperson, the speaker is deliberately misleading the House and South Africans. If he says, can I continue? If he says that the DA came with capitalism and defenders of capitalism's house, it is a program and it's a policy of the ANC
It's
that
not a
they
point
keep
of
on
order.
denying.
Can you take your
and
seat?
the minister can tell us whether you have capitalist policies.
Honorable Julius,
I
take
don't
your
know
seat.
what are you...
Honorable Julius, the very same point that was addressed by Honorable Lond, that if a person is rising and is raising a point of order, it must be a point of order. And that is not a point of order. We are debating with him. Can you continue, Honorable Mtimunye? Honorable Smith?
Honorable House Chair, just on a point of clarity, is tenderpreneurship not also a form of capitalism?
That is not a point of order. Take your seat. Continue, Honorable, and conclude, Honorable.
Thank you, Honorable House Chair. Honorable House Chair, may I take this opportunity to thank the Minister of Trade and Industry, Minister Rob David, for gracing this debate in person. Can I also thank all the members of this House who participated in this debate on behalf of the Office of the Chief Whip, of course, but also thank the Office of the Chief Whip for agreeing to place on record or to place on the schedule of this House this particular debate, which is so important and cardinal to our people. Thank you very much, Chair.
Thank you. Honorable members, allow me to join Honorable Mtimunye on behalf of the Chair, the leadership, the Chief Whip, in thanking you, honorable members, the Minister, for being available to deal with the debate of proliferation of unlawful deduction by credit providers and employers. That concludes the debate and the business of the day. Members are requested to remain standing until the procession has left the chamber. The House is adjourned.